The IRS issued notice IR 2023-193 providing a simplified method for taxpayers to withdraw improper ERC claims. In that notice, the IRS stated that withdrawing a willfully filed fraudulent ERC claim wouldn't prevent the IRS from pursuing criminal penalties against the taxpayer. As I discussed last time, the act of willfully filing a fraudulent tax return can subject you to civil or criminal penalties. Once the return is filed, the act is completed. Later withdrawal of the claim doesn't cure the fraud on the original filing. Tax fraud can subject a taxpayer to heightened civil, meaning monetary penalties. It can also provide the basis for a criminal prosecution. But the IRS must prove tax fraud to impose any such penalties on a taxpayer, and the burden is high. In the context of a filed tax return, the IRS must at least clearly and convincingly establish that a return was filed with the intent to evade tax to establish civil fraud. The IRS's burden to establish criminal liability is beyond a reasonable doubt. In a tax investigation, the IRS always looks for court-recognized badges of fraud, but certain factors specific to the ERC may be used to establish fraud. Perhaps most glaringly, if ERC was claimed for employees that the business didn't employ or for wages that were never paid. In the context of qualifying for the ERC, if a business claims that it had a significant decline in income but never had any such income decline, or if a business contends that it had a partial suspension of business operations but can show no business interruption and no governmental orders affecting the business. These may just be a few of the facts that the IRS could use to establish fraud during an ERC investigation. If you have concerns about a claim that you filed, you should retain counsel to discuss your filing within the confines of the attorney-client privilege.